Then they file the lawsuit. Then they go to federal court, and they basically decide that they're going to stipulate to facts which are completely contrary to the facts that they had previously determined. And our position is you can't do that. They can't, under their code, they can't change facts without a public hearing. Now, as a legal fiction, municipalities only have those powers which are vested in them by statute, and they can only exercise them consistent with what's in the statute. So, for example, if you're a county, town, or village, and you have a zoning code that says they can only grant a permit after a public hearing, the municipality can't grant a permit without a public hearing, even if they're trying to do so to settle a federal case. They don't have more power. It would be no different than if, as part of the settlement, they agreed with the carrier, oh yeah, as part of the settlement, we're going to give you title to Steve and Barbie's car. Okay? They can't do that because they don't have that power. Now, what happened was they stipulated to these facts, they hand it to the judge, and the judge so orders it. And that's the way that got resolved. So now, the attorneys for the municipality are saying, hey, you know, this judge rendered a judgment, and this is a collateral attack on a judgment, which you're not supposed to be able to do. Once the judge makes a judgment, that's that. But there was no real judgment. The reason is the judge never made any actual determination. The judge never had a hearing. The judge never heard testimony, never took evidence, never even entertained a motion. The judge really never made any determinations that were challenging. The judge simply accepted at face value what they said and said, okay, yeah, I'll sign off on it. So they're trying to characterize this as if the judge had a trial and made factual determinations, and now we're trying to attack it collaterally, and we're saying that's nothing could be further from the truth. And the way our judge should look at it is as if instead of the municipality having been a party to the settlement agreement, let's say it was a 5-year-old child signs a settlement agreement. They have no authority to do that. They have no capacity to do that. And so we're only challenging the authority capacity of the municipality in entering that agreement in the first place. So that's the real battle. The only other thing that hurts us is the fact that we didn't file a motion to intervene, but even that I don't think it's fatal. So, you know, I told you guys from the outset this might be a tough case to win. I still like the case. What troubles me most is, you know, their argument about the, you know, not filing the motion to intervene. But the other thing is, the thing that I like the most is I'm telling the judge, we're not looking for anything extraordinary. We're not looking for huge relief. All we're asking is that you say, yeah, they should have had another public hearing and annul their determination and remand it back to the board to make the proper determination over again, have another hearing. So there's no prejudice to anybody, Judge. What's the downside? So that's why I think we have a shot. And we'll see. It's going to go in the hands of the federal judge. So there's 2 motions pending, one from each defendant. One response is due, I think, on the 14th, and one a little later than that. We're pretty much done with them. They'll be finished probably by tomorrow, and we'll be ready to go. And I'll discuss it with Ray, and then I think we have to send them to Ray, and Ray actually has to file them. But we're on top of it. It'll get filed, and we'll do our best.
Wonderful, 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 and that's. I know you will, and I'm grateful for your efforts, and I appreciate the rundown, and I will be available to help, and you know, anything you need, just let me know. I'll be right there.
Great. Now, by the way, there's one other thing. I just sent another email to Ray. I know that 60-day thing you guys were talking about. You know, if they stop the use for 60 days, the tower has to come down. I don't think I'd make that argument in court. It's a tough argument. I think if the municipality is looking to go your way and help, they might try to do that. But you can't cease a use which never began. That's the argument that they're going to come up with, and it's a pretty solid argument. So it's not like the hazard thing was operating and they shut it down for 2 months and let it sit there. That you'd have a good argument. But I just texted Ray. I said, Ray, if you think you can push this, if you think the local government is willing to entertain that argument, then by all means try it. What's the downside, right? I just wouldn't put it in the court proceeding because I think the judge would look at me with a critical eye. And again, all I care about is winning. And you know, I don't do anything improper, but you hired me to achieve an objective. I'm going to try my best. This is a tough case, but I'm going to do my best to try to win. And I think that the better course of action, the one more likely to prevail, is to abstain from putting that inside the lawsuit. But that doesn't mean you can go to the town directly and say, hey, you told them if there's any cessation of use for 60 days, it's got to come down. It's got to come down in 60 days. Let's see what they say.
I agree not putting it in the lawsuit. I don't want to cloud the issue and have there be distraction. That makes sense to me. Do you think engaging on a local level could negatively impact your efforts?
I don't think so. But the federal judge is going to review the case on the federal law. And again, I really like the First Amendment claim, and I hope I win. I hope, again, we're making it easy for the judge to rule in our favor, which is always a good thing. We're saying, Judge, all you got to do is say, yeah, the municipality exceeded its authority. I'm just going to remand it back to make the determination over again. Let these people have a chance to be heard, that's all.
And last question, making it easy for the judge. Do you not think that showing the impropriety as evidenced by the exhibits that I supplied would further that?
No, the most important exhibit is the determination of facts, because our argument is, look, under the code, they had to have a public hearing. And once there's a requirement of public hearing, that triggers the First Amendment. And my client, Mr. Barbie, had the right to go before that public hearing and be heard. That's the whole purpose of a public hearing. So they had a public hearing, they took evidence, and they made factual determinations. Once they make factual determinations, they can't act as an appellate review for their own determinations. They can't then, after the public hearing is closed, now they go into a federal court where we have no chance to be heard or hear what they're considering. And they stipulate to facts which are directly opposite to the facts which they determined at the close of the public hearing. They can't do that. If they want to revisit the factual determinations and consider new evidence or something like that, you have to have another public hearing. Otherwise, what's the purpose of having a public hearing in the first place?
Exactly.
It's a perfectly logical argument, and I will tell you, most judges would side with me. The only problems are that, I try not to make the federal judge look bad, because the federal judge who signed the so order stipulation really just said, oh, you want to stipulate and have me so order, it's fine. And judges do that, but it looks like the judge is making factual determinations when they're not. And I don't want to make the judge look bad at all, because that will simply piss off the judge we have now. So there's some diplomacy involved in this type of thing.
Certainly, yes, of course, and that makes sense to me as well. Okay, very good. We will stand by, and again, you need anything from us, just let me know.
Great. Thank you, Stephen.
Thank you, Andrew. Bye-bye.